$100,000 per year. So the whole idea is no more will these big tech companies or other big companies train foreign workers.
Another major legal challenge has just hit the Trump administration against the $100,000 H-1B visa fee hike. The U.S. Chamber of Commerce, one of America's most powerful business advocacy groups, has filed a lawsuit. Now, according to a report by Newsweek, the U.S. Chamber of Commerce filed its lawsuit on September 16 in the District of Columbia. The case names both the Department of Homeland Security and the Department of State as defendants. The Chamber's main argument is that this fee hike is unlawful. They say the president does not have the legal authority to set or raise visa fees, because fee-setting powers lie with Congress, not the White House. The lawsuit argues the $100,000 charge would cripple small and mid-sized businesses across the United States. It claims the cost would make it impossible for smaller firms to access the kind of global talent they rely on. In fact, the Chamber's executive vice president, Neil Bradley, said in a statement, "The new $100,000 visa fee will make it cost-prohibitive for U.S. employers, especially startups and small and mid-sized businesses, to utilize the H-1B program." This isn't the first lawsuit linked to Trump's immigration and visa policies. Earlier, a multi-party lawsuit was filed against the administration's plan to make new visa applicants pay 10 times more than before. On September 23, 9 complainants, including employee unions and individuals from healthcare, education, agriculture, automobile, and aerospace, filed a lawsuit in a California district court. They're challenging Trump's presidential proclamation that hikes H-1B visa fees from $10,000 to $100,000. The case has been filed through 7 law firms, making it one of the most coordinated legal pushes so far. The complainants are asking the court to declare the order unlawful and continue processing H-1B visas under existing laws. Their main argument? That the president exceeded his authority, because only the U.S. Congress has the power to set or change visa-related fees. So what happens next? The District Court of Northern California, based in San Francisco, will now hear the case. Both sides, the government and the complainants, will present their arguments, and they could even seek an out-of-court settlement. If either side loses, they can appeal to a higher court. To understand what this means, let's look at how the U.S. legal system works. It has 3 levels of courts: district courts, courts of appeals, and the Supreme Court. Complaints like this start at one of 94 district courts. If either side disagrees with the verdict, they can appeal to one of the 13 circuit courts, also known as the U.S. Courts of Appeals. If those rulings conflict, or if the issue is major enough, the case can move to the U.S. Supreme Court, which then decides whether or not to take it up. If a party loses in a lower court, it can request a writ of certiorari, asking the Supreme Court to review the case. The top court usually takes it up only if it sees a significant legal question. If the Supreme Court declines, the lower court's decision stands. Now, if Trump's proclamation is upheld, the complainants can still appeal all the way up to the Supreme Court. But if it's struck down, the order might be barred only within California, since nationwide injunctions have become rare. In fact, in June, the U.S. Supreme Court ruled that district courts were exceeding authority by issuing injunctions beyond their jurisdiction. Just last week, a federal judge in Oregon issued a temporary restraining order, blocking Trump's plan to deploy the National Guard in Portland, after he described the city as war-ravaged. So Trump's H-1B visa fee hike, still just a proposal, now tangled in one of the biggest legal showdowns of his presidency. If the courts block it, it could reshape how immigration and visa policies are handled in the U.S. for years to come.